all for being here. Today, I'm happy to introduce Dr. Christopher Seeds, who is an Assistant Professor of Criminology, Law, and Society at UC Irvine. Dr. Seeds' research takes a historical sociological approach to examining punishment, including laws, policies, and practices related to sentencing, confinement, and prison release. His work has been published in Law and Society Review, Law and Social Inquiry, and several law reviews, among other outlets. He's joining us today to discuss his recent book, Death by Prison, The Emergence of Life Without Parole and Perpetual Confinement, which investigates the rise of life without the possibility of parole, aka LWOP, which has become a routine part of the contemporary U.S. criminal justice system. Dr. Seeds will speak about his book, and then the Q&A will follow after. For those on Zoom, if you have any questions, please feel free to type them in chat as we go, and we'll get to them during the Q&A. So please join me in welcoming Dr. Christopher Seeds.
Thanks everybody for spending your lunch here today, both in the room there and online. You know, what I'd like to do is I'd like to tell you about what the book finds, and then I don't really offer policy arguments in the book, but I'd like to, maybe we can use our discussion to think what it might be, or to begin to, because I think the way I see the book is it lays out a research process and my findings, and it's a sociological account, but it's not a policy argument, and it kind of sets the foundation for potential policy arguments. But I think the next step is, well, what do we do with this information in these books? So what I'd like to do for this 20-25 minutes that I'm going to talk is tell you what I found, and then, of course, we can follow up with questions about, about that, about the study if you want, and about the history. But I think it would be also interesting to talk about what do you do with this? What are the policy implications of this? How could it be used? So I have a slideshow. Is that something I can share, Kevin?
Yeah, just one moment.
I shouldn't say slideshow, it's just slides that I think there's a do this. Life without parole is that fair?
Yes.
So,
It still might be helpful to give like a brief overview or definition of it.
okay, yeah, let's do that. So I'm going to try to whip through this. What I've got is basically it's a 40-minute talk. I'm going to try to 40 minutes. Hang on. Okay, can you all see that?
Yeah.
The slideshow? Or
Yep.
PowerPoint?
Yes. Yes.
Okay, good. Okay, so LWOP. We've seen that around before. But did you know that up until the early 1970s, there was no use of that in a national newspaper in the United States to mean anything other than leave without pay. And only in the late 70s do you start to see a trickle to life without parole with that acronym. About 5 per year in the late 70s. But by the time you get to, say, 2006 or 2016, which I actually looked at in national newspapers, you've got about 5,000 references to LWOP in the newspapers like that. So you can see that's something just as a cultural artifact that changes over that time. So what is it? Let's just go through it real quick. I think we already know that, well, first of all, it's something that is racially disproportionate. 2/3 of the people serving life are black in this country. 5 black men in prison serving some sort of life sentence. If you're looking at, you also know that women serving LWOP, growing, the number of women is growing at a rate that's quite a bit faster than in the recent 9%. And it's something that, youth are still serving in this country. I'm sure you guys know about, Miller and Graham and Montgomery. Yeah, it's not okay to sentence you to LWOP anymore. That's another matter. My book doesn't get into that, but yet there's relief in American prisons, and it's something that affects increasingly is something about age. A lot of the folks who went in there a lot in the early 2000s are becoming older adults in prison, and the as you know, the landscape isn't getting older, it's changing, and OWOP and life sentencing is part of that. So that's the beginning, but we could also say more, bringing some descriptive stats like this one. Dirk Van Smith, Catherine Appleton published a helpful book in 2019 where they looked at LWOP. And these are the countries that have LWOP, by which we mean a prison sentence where you're reasonably likely to end your life in prison, really a death in prison sentence. But the United States has got a whole different right way off the charts. Another point I think is important is that the national prison population has tapered off a little bit in recent years, and unfortunately it's specific, but the OWOP population, part of that I think has to do with bifurcation in sentencing reform policy. Again, that's another issue we can get into later if we want to. And yet another point I think that's significant, and this one I want to emphasize, is that when we talk about LWOP as a death in prison sentence, we shouldn't leave out the other kinds of death in prison sentences that there are. So these are the top 5 states in terms of LWOP sentences. But Texas and Indiana don't have a lot of LWOP, but they've got, in this case, 50 years, sentences of a mandatory 50 years or more. So should we think of those as the same thing? And I think we should. The Sentencing Project says we should. And if you do, you see that while Florida's gotten more than these now, Florida's got 10,000. Texas has only got 1,200 serving LWOP, if relatively speaking only. But yet the total number of people, when you add in the virtual life sentences in Texas, of which there are many, is not that much different. So the point being that we're really the object, whether it's policy reform, abolition, sociological study, the object really is death in prison sentencing. It should be, I think, not just LWOP. So, how do we address the fact that a certain number of people are going to spend their lives, they're going to die inside, whether it's at LWOP or an extremely long sentence. So those are some initial points. When I do this talk, I often go through the Graham sentencing proceeding and kind of give an example of what an LWOP sentencing looks like. And I think that would be interesting to do here, but I also don't think there's time. I just want to emphasize one point about the Graham sentencing. That it was a relatively normal sentencing proceeding. It wasn't particularly long. Graham was serving while he was arrested on an attempted robbery with a weapon charge, which he pled guilty, and then he got out. A couple of years later, he got arrested for an armed robbery charge, and he was facing a sentence of 5 years to life in prison. That was the amazing thing about this. And the court proceeding is one that for years, and yet he got LWOP. The district attorney asked for 30 years. The attorney asked for 15. The judge gave him the whole package with these words that are up on the screen. That, I think, is remarkable. That in a sense, a death in prison sentence is something that's more or less routine. When you compare that to what the intervention has required, right, for capital sentencing, and if you think of to a death sentence, which it is, right, it is a type of death sentence, the fact that it can be meted out after a proceeding like this one. And of course, it can't be any more technically for somebody who did the crimes that Graham did. But the point is, not just the the facts of this case, but the way the sentencing proceeding took place, that's the way LWOP sentencing proceedings take place. There's nothing special about putting somebody away until they die. And that's kind of the baseline for how I got into this research. How did we get to this place where that's the way things are? So I'm going to skip over on a method a bit. And I look back into the history of life without parole, and I really go back to the beginning of the country, looking at primary and secondary historical materials. And then I move up to, I really focus on the mass incarceration era. And so I'll be talking about what I find. And I think the first important finding is that I like to think of life without parole history, speaking death in prison history, death in prison sentencing history, also with LWOP, driver of it. But here's the first key point, is that before 1972, there are life without parole. There are life sentences that are parolable, and there are life sentences that don't have parole. And that might be in a criminal statute, it might be in a parole statute. But the upshot that I want to emphasize is that what made life without parole distinct before 1972 was principally who had the authority to make the decision about release. So the parole board didn't have it. And instead, it was vested in the executive, in the governor, and the governor's, board and whatever they call it in any given state. And in that circumstance, it didn't necessarily mean death in prison. There were in certain states that had all life sentences as without parole, pretty regular and ingrained routine practices. For instance, you might know Louisiana, which had a 10-year 6-month rule. So if someone sentenced to life without parole in Louisiana, served 10 years and 6 months, there was a protocol that the warden of the prison where they were would write a letter of recommendation to the governor's clemency board, and they'd be reviewed. So in essence, a life sentence in Louisiana was a life with clemency review sentence after 10 years and 6 months. Pennsylvania is something similar. And actually, if you look back at Pennsylvania, 1940s, a parole board expert actually did a statistical report on release for lifers and releases by parole and their recidivism rates and the materials reviewed and the process of review and release. And he thought that clemency was a more thorough and reliable decision-making process than parole was at that point. So my point being, life without parole is not a death in prison sentence by definition before the 1970s. It's a life with a possibility of review by the executive. And of course, we know there are differences between parole and clemency that are significant, but I like to think of it as a continuum, more or less. On the one hand, you've got a board of experts deciding parole according to some kind of administrative expertise. On the other hand, you've got clemency, which is the subjective decision, the mercy decision of the government. There's a lot of gray area, right? You have talking about in Pennsylvania that maybe is more reliable than a parole board that's filled with people who are really just doing whatever they want. So, point 72, life with parole, life without parole, they're two different paths, but they're not necessarily that different in terms of their outcomes. And we can look at the length of time people are spending under life with and life without, and they wouldn't be that. They'd be different, but they wouldn't be like differences of type so much. Okay, that's the first point I want to make. Now what I'd like to do is go through this process of transformation, which is period 2, because my argument is that between the early 70s and the early 90s, the foundations of the landscape in American punishment change in significant ways that also bring about or enable the development of life without parole into death in prison sentence. And then from the early 90s onward, you really got LWOP as we know it. It's a no reasonable possibility of release sentence. So let me show you a chart real quick that I think is significant. If you look at those states I showed earlier, the ones with the most length right here. And this is 1992. This is a number of people serving life without parole in American states in 1992. And the top 5 states are the ones in, top 6 jurisdictions are the ones in gray. I've added the federal system at the end there. If you look at the same stat in 2016 in the Sentencing Project report, you get this. And if you look at it, it's the same exact states that are leading. And there's more LWOP everywhere, right? But it's the same states. And the point I take from this, or emphasize with it, I'm going to back up and we're going to talk about what happens, is that by 1992, there's a lot of foundations set. And things have been proliferating since then. But the foundations of life without parole, as it exists now, are substantially set by 1992. So what this book does is it focuses on this period too, and looks in closely to what happened. And so that's just the outline. And I'm going to work through these chapters really quickly because I know we're already like 20 minutes into this meeting. But I think we'll talk for 10 minutes and we can open it up. The book opens up with the first 2 chapters being kind of background. I kind of go through what LWOP is, we've already talked about here. I talk about the pre-1972 situation, which chapters 1 and 2 gets into some social theory in the first chapter there. But then chapters 4, 5, and 6 have to do with the transformations. And 7, 8, and 9 have to do with how those transformations kind of get solidified in practice and understandings, and the result is LWOP. So let me tell you what I mean. The transformations, there's 3 that I think are really significant, and you know them already. This way. The first one's Furman versus Georgia. It invalidates death sentencing across the United States for 4 years, right? Gregg versus Georgia in 76, the modern death penalty as we know it begins, and it's approved to begin. But what happens in 72 is death rows are cleared, commutations to life sentences happen, and states start to think about, well, do we want death penalty? Review it, and a lot of them come back, 30 states come back with their new death penalty statutes, or a set, which the Supreme Court will then review. If you read, I think, a lot of the existing literature on the death penalty that kind of refers to LWOP almost in passing, and there are some books that do more with LWOP than others, like the Steiger's book, Courting Death, deals with LWOP seriously. But even there, you find that the way that LWOP's referred to in relation to Furman versus Georgia is as a backlash, like, well, we can't do the death penalty, so we need LWOP. That's not really true. It did happen that way, because and there were certain people at that time that were arguing that life without parole sentence should mean death in prison. There have always been people like that, or people like that in the 20s too. I show examples out of the book, but that was a very, very minority perspective on a life without parole, and it wasn't the one that actually represented real practice in the state. So, point being, in 1972, LWOP doesn't exist as we know it. So this idea of a backlash to a death in prison sentence there called LWOP, it didn't happen. And part of the reason it didn't happen because LWOP, as we know it now, which I'm saying is something from the early 90s onward, wasn't there. But that doesn't mean Furman wasn't really significant, because what Furman took the death penalty off the table and made people the worst of the worst people. And the answer was the life sentence, which meant some term of years, usually less than 20. And that was not very comforting to people in the criminal justice system. And so you get a much more scrutinized look at life sentencing. You get debates and discussions opening up new pathways where life doesn't mean life, but should it? And you also get structural adjustments where minimum sentences get raised and life gets a minimum sentence attached to it, all in response to these worries about, well, if we go to death. So that's one of the major transformations. The second is the fall of the rehabilitative ideal, by which I mean rehabilitation as a driving paradigm in American corrections. And life sentence with parole, that was the classic, that was the paradigmatic sentence for the rehabilitative model of. And when that comes under fire from all sorts of angles, in the details here, in the 70s, right? And states cut back on parole, states become more interested in fixed determinate sentencing. We know how determinate sentencing idea was not necessarily a massively punitive one. It was one that wanted to determine sentences rather than open-ended ones, because the perspective was that open-ended sentencing allowed itself to abuses of discretion by parole officers or parole commissioners or by judges. But whereas a fixed sentence, they didn't have that chance to kind of abuse their power and keep people in longer than they should, or not as long as they should. But when the rehabilitation to retrench, what happens there too, decisions are made about life sentences. Life sentences a lot more in certain ways than other sentences. So imagine that if you have a sentence and they decide there's too much game time or good time, too much time taken off of it, it wasn't really looking like it should, like a 15-year sentence, maybe you're getting out in 7, adjustments can be made. Or if you're getting out on parole, adjustments can be made to make the. I'm not explaining this part very well. I recognize that. No one's going to be clear anyway. What happens with life, though, is that there's no number attached to life. So when states are pulling back on parole and they're wondering what are our sentences going to become if we don't have parole, what's the fixed sentence going to be for that? Well, with life, I mean, I'm serious. There are quotes like this in the legislative materials that I researched where they're just like, well, what's a percentage of life? We can't do we can't have, game time provision for a life sentence. So we just, I guess life means life. And basically LWOP's created, guys. LWOP's created through this. Almost as it's almost like just an artifact of transition in some ways. We can come back to that more. These mechanisms I was talking about, Louisiana, Pennsylvania, stuff like that, starts to dry up. And states that remove parole, they lack developed practices like that anyway. And then you find, as we're well aware of, it's been happening for a long time now, you find governors using clemency as a political tool. Not giving clemency as a political tool. So that happens too. All three of those changes change the meaning of what life without parole is. It goes from being a sentence that has some kind of reliable opportunity for review to one that doesn't. And what that means in practice and on the ground is that, well, eventually incarcerated people recognize this, they start mitigating it. And over time, challenges funnel up through the United States Supreme Court, and you find the Supreme Court change in how they perceive life sentences also. And it's interesting because their perspectives on life sentences are changing with those transformations I noted before. And in the book, I kind of walk through how these major transformations funnel themselves through litigation by incarcerated people, and then ultimately are affecting the landscape of the Supreme Court's decisions, which is this legal doctrine column there. And what happens through these cases is that they go life without parole by looking to the back end to see what the sentence actually amounted to on the ground, to not even bothering to look at the back end, just assuming that it's a death in prison sentence, which is where you get to with Harlan versus Michigan, when Ron Harlan is convicted of life without parole drug offense for possession of a massive amount of cocaine, but yet it was a first-time drug offense. And with upholding that sentence, LWOP becomes a death in prison. It's well known, it's a death in prison sentence, and it's one that can be used for a lot of things. So I think that's one key moment. Another key moment is the anti-death penalty movement, recognizing that LWOP is a death in prison sentence. And again, I'm just going to talk for about 3 or 4 more minutes, and that's okay. Some folks see the reaction to the death penalty in the 70s as where LWOP begins, the anti-death penalty movement, but the anti-death penalty movement always about LWOP. And there's a great book by Harold Haynes, I think his name's Harold, but by Haynes on the anti-death penalty movement that I highly recommend, but he shows in that book clearly. And I find more corroborating evidence of that in my research, that the movement's conflicted, and they don't want to even talk about an alternative for a while. The time 1993 comes around, there's a new media campaign, which is really manifesting that you've got LWOP all over the place, as this chart we looked at showed, right? You've already got all this. And so what the National Death Penalty Movement's doing in 93 is they're saying, you've already got all this, and yet most of that's not death penalty. For instance, Florida didn't have LWOP for the death penalty, they had LWOP. So the National Death Penalty Movement's argument in 93 as well, it's already there for a lot of things. It's not there for the death penalty in all these states, especially southern states. So let's just, we're not making anything new. We're not doing the worst thing ever. We're just saying it's already there. So let's use that as a tool for getting rid of the death penalty. And you see in that kind of move something that I want to emphasize in closing, which has to do with disregard being a primary and really significant factor in how LWOP builds, death in prison builds. Okay, the last solidification, as I call it, or institutionalization of life without parole as death in prison sentencing, has to do with penal administrators and prison building. It makes sense if you think about it, but the strongest opponents to LWOP for most of the 20th century into the 70s were prison administrators. Nobody wants a prison filled with people who know they're not going to get out because they don't have hope and it makes them more dangerous. That's the argument that prison administrators held fast to. So after Furman, prison administrators were like, bring back the death penalty, whatever you do, don't make prison sentences that don't have an end point on them. That's not something that has been done very much, and there's a good reason for it. That was their argument. But by the late 80s, early 90s, LWOP's around. It's a natural fact, as I say there. So they got no choice but to take a different tack, and you find prison administrators pushing for more prison building there to really give them more space, in a way, as a means of promoting prison safety. Okay, last thing I want to talk about is, what do we take away from this? And you might have your own ideas, but here's the first point is really about, it's almost for related to, to how to study punishment and how to understand it, but it can play into how we think about policy too, which is that LWOP wasn't always death in prison. And those changes, those transformations I talked about, created a context in which it became that way. So concepts arise in context, practices take hold when they resonate with what's happening around them. I think that's important to remember. It's not just about actors having ideas that happen to work better in certain situations, which is also true. It's also that the way people think about things can change by the way things are. So last point I want to make, and this is really, I think, a really important one of the book, death in prison sentencing in the 70s. And you look at the role of death in prison sentencing, which I haven't gotten into here, which we could talk about historically in the United States, by which I don't have time to get into it, but you find that it's not always punitiveness that's driving this. I mean, largely it is since the 90s in this country, like punitive sentencing policy. But alongside, folks who are clamoring for harsher sentencing, in the earlier moments in which LWOP becomes death in prison sentencing, it's disregard, it's a lack of care or attention to how the people are being punished and to the effects of changes in penal laws when people are punished. That's motivating a lot of this move that's creating OWOP. So a lot of what this book does, I think, is it shows how disregard works alongside punitiveness in developing OWOP as a death in prison sentence. And here's some examples. I can just leave this up on I've got general ways, specific ways that I think I see OWOP happening throughout all these processes. But the upshot is that there's something more to extreme sentencing and its growth than just harsh punishment. I mean, we think of, and this is where race plays into this too. Race is on the face of some of the harsh sentencing policy. It's the discriminatory effects of race are in action in all criminal justice operations, all the way along the line from policing to arrest up through sentencing. That happens with LWOP too. But in addition, there's a aspect of not caring about the people who are being sentenced in a way that allows extreme punishments, allows death in prison sentencing to happen. But I think the genealogy, which is what I call this historical approach I take in this book to life without parole, really shows us. And if you think back to historical, I said I wasn't going to get into it, but let me just offer a couple examples in way of closing. If you think back to death in prison sentencing, it was never as central as it is now. With LWOP, death in prison sentencing, that includes virtual life sentences, which I think often take a lead from LWOP in how they're used. But it always existed. It started with the prison. If you think of Benjamin Rush, I don't know how much you folks have studied, original American penal theories, but if you think of Benjamin Rush in the early Pennsylvania prison, his idea was that it was a social education project, and people would go in there with sentences that had no defined time on them, and they'd stay in there until they were. And the folks who went in there, in his view, were people who were expendable, essentially, unless they became socially educated and worked themselves out. Same basic idea underlies the indiscriminate sentencing approach that the progressive era brings in. I mean, in one way, it's very optimistic for the incarcerated person because they have a chance for review. But on the other hand, it's completely open-ended, and you might never get out, which is an extraordinary thing if you think about it, right? I know when I was a capital defense lawyer, before I started studying my sentencing, I thought rehabilitation is a good thing. That's recognized in the system, that a person can get out by rehabilitating and that being recognized. But the flip side of that whole operation is that you can never get out. And if you think about the power of the state in that case, it's massive. And this is that very reason is why the rehabilitation approach never caught on in Europe, because they viewed it as almost like absolute state power and were very wary of it. So they preferred fixed sentences to that. And when you had situations where a person couldn't get out or it was dangerous, that's when civil commitment comes in European states. So it's a different way of looking at things. But the point being that there's an idea about people who are incarcerated being expendable, being potentially somebody you could put in forever, that I think underlies that operation too. Same thing with convict leasing. Convict leasing is a potential death sentence under horrible conditions, and but you might be put in for vagrancy, right? You might be put in for a relatively minor offense, and yet your sentence is going to put you in a situation where you could die. There's a lot of disregard. There's a lot of lack of caring, a lot of indignity for incarcerated people in all these examples. And I think that the rise of LWOP, which this book details, is just another example of this. All these decisions that were going on, not all of them, but many of these decisions that were going on creating life without parole as a death in prison sentence during these years were ones in which people accepted this. They didn't challenge it. They weren't paying close attention to it, or it just, there's all sorts of assumptions about the expendability, excludability of the people getting the sentences that that underlie these operations as much as punitiveness. Okay, so I'm going to stop there. I went a little over what we expected, but I hope that's okay.
Yeah, that's totally fine. Thank you, Dr. Seeds. We'll now open it up for Q&A. Anyone has any pressing questions? Yeah.
So I have a lot of questions, but I think maybe the first, I'm wondering if you can speak a little bit more about, like, basically who was behind, who made up the movement to end the death penalty. You know, what kind of organizations was it? What role did like families or communities impacted by incarceration have in that movement? Yeah, I think that's the first.
All right, now, okay, thanks for the question. And just to clarify, which movement are you talking about and what years? And are we talking about the national death penalty movement? Because there's a death penalty movement in many states, and it's been something that's been ongoing. My book's focusing really on the 70s to the 90s. What you're interested in?
Honestly, maybe any of the above, but I mean, I think what I'm interested in particular was kind of what dynamics drove the maybe lack of attention to the effect that ending the death penalty or advocating against the death penalty might have on the rise of life without parole sentences.
Okay, I'm sorry. Could you rephrase the question? I didn't totally.
Sure.
I'm going to respond to what you want. Yeah, can you just say it one different way?
So you discussed how the rise of life without parole sentencing was in part a product of the movement or movements, collective movements to end the death penalty, whether national or in states. And I'm wondering, I guess I'm hoping to hear a little bit more about that dynamic. Like, is your sense that whether on the federal or state level, movements to end the death penalty were just not aware of, you know, I know you said that they basically treated the death penalty as a problem to be dealt with kind of later, but I generally am interested in hearing more.
Thank you. Okay. Yeah, so I'm going to look at this at the national level because that's where I studied it. I studied it in the National Death Penalty Archive, and by national level, I mean like the litigation organizing that's going on in the NAACP Legal Defense Fund that's leading up to Furman and then follows Furman. The kind of discussions at a national level that happen at national conferences like NAACP, LDF conferences. Airley's a big death penalty conference. I used to be a capital defense lawyer for 15 years before I went to grad school, by the way. So I've got understanding about the perspective of the capital defense world, and frankly, I took LWOP for granted for a long time. That's not to say that the movement did. But I think there's a few things. One is I don't think LWOP meant what we know it. So if you asked, say somebody like Michael Meltzer, who was one of the primary legal defense funds lawyers in the 60s working in Furman, whether he was advocating for LWOP, you'd be like, LWOP as we know it didn't even exist then, so it wasn't something we were thinking about as an alternative. But then, what I show in the book, there's a chapter dedicated to this, is that there was a lot of uncertainty in the movement and discomfort about selecting an alternative that was going to be extremely harsh. And there were some people, some really prominent people, who in the 80s, I think prison sentence that results in death is the way to go on this. But then there were other people that were vociferous against that, just like absolutely no way. And so most of the work I'm looking at in the book and social scientists, academics, and the reason for that is at a national level in the 70s, the movement is really driven by lawyers. I mean, what makes, and there's books on this, right? There are books on the emphasize that what made the national death penalty and national anti-death penalty movement different from prior anti-death penalty movements in that era was that it was driven by lawyers. And so I do focus mostly on the lawyers, less on families, less on community organizing. And in part that's because the archives I'm working with are the archives of these organizations, and that's where my data is coming from. So that's not to say there weren't people out there in communities and families who were doing a ton of work also, but what I'm focusing on in the book is how the national organizing through the institutions that were building up around this, the ACLU, and then the Death Penalty Information Center, were doing. And what really ultimately, like I said, I think OWOP's just it's a dogfight. And people have very different views on it. But what kind of solidifies it ultimately is the fact that OWOP is real. It's suddenly a death in prison sentence being used a lot. And when you think about the Harlem case, it's something that could be used for drugs, it's really out there. And I think that helps bring a lot of people in the national movement who were really uncomfortable to it, because in a way they're not championing a new thing anymore. They're not saying we need to change this and bring in this awful thing. It's already there. And so I think in just a really general sense, the way that I'm framing the national anti-death penalty movement's role is a bit different than how I think death penalty activism is often thought about with LWOP's emergence is they're not leaders, they're followers. And that's not to say they aren't really, really important. It's huge in making LWOP more prominent since then, but they're followers. They weren't like the original drivers of that brought LWOP into being. Your question.
Thank you.
Great. Yeah, Adele?
So, as some context for this question, I am a psychologist by training, and I'm not from the US. One thing that's always struck me about LWOP and also the death penalty together is they're both sort of grounded in this idea that there's nothing that person could do to redeem themselves at any point in their life. Like, that's it, you're done. And I wonder if, to me that seems like it would be like a cultural thing. And I don't know if that's a cultural thing that has existed always or is something that exists in this particular sphere of America or whatever, but I'm just wondering, given that you've looked at the history of this, if you saw any kind of cultural change in that viewpoint, and if you can speak to that.
Thanks. And just to clarify, are you talking about the relationship between LWOP and the death penalty, or just the
existence of both of them
as a death sentence?
Yeah, so it's like they're both punishments that are grounded in the fact that there's nothing that person could potentially do to make themselves worthy of a life outside of prison or at all, again, because of what they did.
Yeah, change in that over time. Yeah, I mean, I think if I'm understanding your question right, that's what this book's about. It's about how this country started to look at death and prison sentencing as something that was relatively normal. Because I don't think that's at all the case prior to the 1970s. And it's certainly the case now. So how did that happen? I think how it happened is largely what I'm talking about here. And then there's a lot more to it from the 90s onward. But the point being that a lot of the foundations of that growth, the terrain that made it possible, was set through all the things we've just been talking about here. I think the relationship between the death penalty as being sentences that don't recognize rehabilitation is really important. And one way that landscape changed in the 70s, 80s, 90s, in the Supreme Court's approach to LWOP that's significant is that the United States Supreme Court, in the early days of the contemporary modern death penalty jurisprudence, the death is different jurisprudence was rooted, folks already, but it was rooted in rehabilitation as a distinguisher. What made that death different? It doesn't recognize rehabilitation. Now, if that's your argument, then LWOP's also a problem, right? Once we get to the 90s and it's a death in prison sentence. But what happened in the early 90s, and Justice Rehnquist is the pallbearer of this change, is that what makes death different in the Eighth Amendment is rewritten. It's no longer rehabilitation. It's incarceration, it's imprisonment. So what makes death different is it's not a prison sentence. So it's rewritten. In this era where rehabilitation is falling away, the rationale for distinguishing death from an acceptable punishment is rewritten from rehabilitation to not prison. And that's really significant for LWOP because it goes from being on one side of the line to the other. What would have been, unconscionable, not unconscionable, would have been an Eighth Amendment violation if rehabilitation is the line. Now is okay because prison is the line. And the cases where that happens are principally Rommel versus Estelle, Hutto versus Davis, Solomon versus Helm, these kind of early 80s Supreme Court cases.
Yeah, I guess my question is sort of a follow-up to Adele's in that the premise of her question sort of assumed a similarity of justification between LWOP and the death penalty. And I actually have always sort of seen them differently in my work doing appellate criminal defense, most often, and in part because I'm representing juveniles who have LWOP, but there, the justification of sentencing, you have to consider rehabilitation potential, but so there, I see the sentence more, for those who are proponents of LWOP as being justified in the lack of rehabilitation. But in the death penalty context, when I've worked on death penalty litigation, when I look at the transcripts that are involved, it seems to center more around retribution. And so when we think about the theories of punishment, and whether it's deterrence, retribution, incapacitation, etc., for me, it has always seemed like death penalty and life without parole are sort of viewed in the culture differently. And so I'm interested, Dr. Seeds, in hearing your take on do you see the justification and for those who are advocates or proponents of using them, do you see the, justification being aligned, or do you see them as having sort of distinguishing characteristics the way I've sort of viewed them, I guess?
Yeah, that's really interesting. Let's just take your definitions as being the definitions, okay? So the death penalty is primarily retributive. And if that's the case, I think there is a distinction. And one thing that complicates LWOP penalty as an ultimate punishment is that it is so multifaceted. The death penalty is the death penalty, right? There's a death penalty statute. It's an execution. There's a practice around the execution. There's protocols, but it's an execution. Life without parole, all sorts of different ways. Death in prison, you can get there a lot of different ways. And the rationale for what's happening and why the sentence is justified is also, I think, incapacitation plays a much bigger role with LWOP than it does with the death penalty, right? You're not incapacitating with the death penalty. You're retributively killing. The notion of incorrigibility, inability to rehabilitate, I think that's inherent in the death penalty too, actually, although maybe you're right, it's mostly retributive. But I think in the history of LWOP, I think that there's more dynamic, there's more of a confluence of the different theories of punishment all being marshaled to support it, whereas the death penalty, if we're going to take your definition of it, is largely retributive. And when you look at key Supreme Court cases on LWOP, else getting thrown in a big jumble. It's not like they're relying on one.
Yeah. I think that's right. That's interesting. Thanks.
Sort of to follow up on that, because in one of the chapters you talk about the role of the Supreme Court in shaping the meaning of perpetual confinement. And we might think about this in other criminal justice areas where a Supreme Court decision creates a standard, but there's no guidance on what that standard really means. And so I was wondering if you could speak more about the importance of legal ambiguity, particularly in how states interpret these federal decisions.
Okay, I'm going to answer that rather specifically by just looking at, say, what did states do after the key decisions like Solomon versus Helm that kind of started to define things differently for life without parole.
Yeah.
Solomon versus Helm is a case out of South Dakota where Helm argues that, I mean, it's a recidivist case. He's got 7 relatively minor crimes, and under an old statute in South Dakota, that means as an habitual criminal, he's getting LWOP for that 7th time offense. And he's arguing, LWOP wasn't always LWOP as we're understanding it here. I used to be, have clemency opportunity that was real. And as they're deciding that issue, they also kind of rewrite the non-capital proportionality jurisprudence, right? So this is a time in the 80s where you got the 8th Amendment capital jurisprudence really developing. It's not so developed on the other end. Solomon tries to lay down a standard for it. And it also finds that it's going to be very rare that standard's ever going to be satisfied, right? But in Helm's case, they find that it is. A prison sentence is essentially going to be a death sentence from that is no good. So there's a question coming out of that is, well, what's that mean? And what's disproportionality going to mean? You could read that case, right? You can imagine courts going to, I hope I'm answering your question with this, but what are courts going to do with that ruling? Where there's a non-capital proportionality and it's supposed to be rare, and yet, it can be had. How are you going to read that? And courts read it conservatively for the most part, and there's like lots of law review notes on the reaction to this, but mostly what happened was that courts were very conservative in their findings, and generally speaking, it was almost certainly going to result in death that was considered even something you would consider as coming close enough to get relief under. So I think in the LWOP history, you see courts reading decisions that opportunities to grant relief very conservatively in this area. And what's important about that too, though, is that the way that they also contributed to defining life with parole and life without parole, because to read it narrowly, like Solomon versus Helm narrowly, to say it applies only to a death in prison sentence, they were also basically saying a life with parole sentence isn't a death in prison sentence. And so there was a reluctance to even really consider this seriously in life with parole context. So I hope that wasn't too rambling, it may be interesting, but I'd say maybe go back to that chapter and look a little bit more. I'm sure there's a more specific answer to your question than what I just gave, but that's where we're at.
Helpful. So I think we have time for maybe one more question. Or, yeah.
The answer might be you just haven't looked into it, which is okay. But I'm just curious if you, in your research, came across any correlation with the use of solitary confinement kind of with the rise of LWOP.
That's interesting. What did you say the answer was?
Well, I don't have an answer, but I think just kind of what you were talking about with prison administration kind of the fear that having folks who like don't have the concern of potentially getting out one day, whether or not that has led to kind of harsher management policies, for lack of a better word?
That's a great question, actually, and I don't know the answer, but I bet there. And I think the idea that those are related is true. You know, my neighbor at UCI is Cameron Ryder, who studies ASSEG and solitary confinement a lot. So I should probably knock on her door when we should have that conversation. That's a great question, and I think you're probably right.
All right,
And of course, it being varied everywhere, but just, you know, in general, I think that dynamic probably exists.
Great. So I think we just reached time. So thank you again, Dr. Seeds, for joining us.
I think it's important, and you know, we didn't talk about policy at all. And, maybe do think that if you want to take something with you from this, think about disregard as a way that extreme punishments get generated, and think about, well, what would you do with that in a policy context.
Thank you. Yeah.
Thank you.